Ladies and gentlemen, this is our last session. We've saved the best for the last. This is going to be our final plenary session. My name again is Richard Bennett, the convener of the conference, and I'm so pleased that we have this session on the heritage of freedoms in Iowa. Our three honored speakers today are, first of all, Professor Collin Mangum, Creighton Law School here in Omaha, the AA and Ethel Yossem Endowed Chair in Legal Ethics since 1991, a tenured full professor since 1985, associate professor 82 to 85. Current courses at Creighton School of Law, which he teaches, is Jurisprudence, Evidence, Scientific Evidence, Advanced Trial Practice, Arbitration, and Trial Theory. Let's just say a legal historian. At Creighton University, he's done so much on so many committees, and I would also add that he is a temple worker, a counselor in the temple presidency of the Winter Quarters Omaha Temple. It's great to have Collin with us. He's written widely on Mormon history, including Zion in the Courts, co-author of that, one of the finest works on Mormon legal history. He and Professor Firmage on that fine work. Our second speaker, I'm so pleased that he's able to come, Tom Schmidt, who for years, some 50 years in the publishing business, the Daily Nonpareil, Winter Quarters, Council Bluffs, president and publisher. He retired, is that 2000? When was that, Tom, that you retired in?
November 6, 2020.
2020, that's right. Prior to coming to Council Bluffs, Tom served as publisher of 9 other newspapers during his career, including 2 years as publisher of the Daily Sentinel in the mid-1990s. He began his career at the age of 18, selling ads for a newspaper in his hometown of Farmington, Missouri. Tom has also served as president and director of local sales for Lee Enterprises in Clarinda and Shenandoah, as well as for weekly newspapers in Bellevue, Gretna, Papillion, Ralston, and Plattsmouth, Nebraska. Tom has had a wonderful career and has served the Council Bluffs community extremely well, and has been a dynamic leader here in Council Bluffs over the many, many years that he's served here. So it's great to have Tom with us. Tom's address today will be on the challenges facing freedom of the press in Iowa, past and present. Our final speaker will be Professor G. Michael Fenner, J.D., Creighton, University of Creighton's first James L. Coley 54 Endowed Professor of Constitutional Law, which he received in 2001. He taught his last class in 2019 and officially assumed the title of Professor Emeritus in that same year. During his 47-year tenure, he worked under 8 deans. Over the years, he has taught constitutional law, evidence, First Amendment freedom of speech, trial advocacy, and Supreme Court seminar with Clarence Thomas, Senior Associate Justice in the United States Supreme Court. He has been very much involved in the Nebraska Law Association and has served in various political positions within the Democratic Party in Nebraska, and has been a great advocate of the freedom of speech here in the Midwest. And so we're pleased to have these 3 fine speakers. First, from Professor Mangum, the death of free exercise, religious freedoms in Iowa. Then from Tom, the challenges facing freedom of the press. And then finally from Professor Fenner, He said his topic is simply freedom of speech. Collin?
Thanks. I'll see if I can, 20 minutes, I can capture the concept that we're talking about here. Really, in essence, the point of free exercise of religion, and it's an eternal, it's something that's been going on even in the premortal existence, but it's something certainly is going on throughout history, is this curious idea that sometimes people are inspired by faith. And their inspiration is so compelling that they want to do something that the state that has the muscle says, no, not so much. We're not going to let you do that. And so the principle it's in place here is really the problem of people who are inspired by religion and are willing to die by that inspiration. A lot of the history you've been hearing the last couple of days are about people who left everything, gave up everything, and died. My grandmother, my fourth great-grandmother, is buried in Winter Quarters Temple gravesite with a granddaughter. They converted, they followed their faith, and they died, many of them, in the process of doing it. And the free exercise of religion deals with the point is, can we tolerate? It really asked of the state, are you willing to be humble enough to let people live their religion without severe persecution? About the same time Joseph Smith was working on the revelations in the Doctrine and Covenants, Lord Acton, a British politician, gave the statement, power corrupts, absolute power corrupts absolutely. Joseph Smith, in Revelation, the DNC 121:39 said, interesting, very powerful, powerful section of the Doctrine and Covenant, has so much to give. But one of the points it says, we have learned by sad experience that it is the nature and disposition of almost all men, as soon as they get a little authority as they suppose, they will immediately begin to exercise unrighteous dominion. And that is true. That's been true for cross-cultural, cross-historical, certainly with the United States. In this particular case, as we're controlled by both statute and constitutional provisions by the Supreme Court, you get 5 votes. You can exercise unrighteous dominion. And that's the battle of free exercise. The hope of free exercise is the state will have enough humility to say they do not know for certain truth. And truth can be revealed by sources other than the state, other than by political vote. That perhaps there's something that's super rational, that's eternal, that speaks to the spirit, not to the mind. Certainly my belief is that we have a spiritual understanding and sensitivity, and if you listen to the whispering of the Spirit, you will be informed what you need to do. Now the question is, if you're informed to do something and the state says, no, if you're going to do that, we're going to penalize you, you get the problem of what do you do at that point in time. That's the issue of free exercise. I love this quote. And this is how I feel, and this is how many of these martyrs, in fact, many of the martyrs that came through Iowa. And if it seem evil to you and to serve the Lord, choose you this day whom you shall serve. But for me and my house, we will serve the Lord. Now, if you're willing to say that, obedience, I will go and do. In the Jewish term, it's hineni, right? You ask, I will do. That's a Jewish phrase. You ask, I will do. If that's the case, free exercise becomes a really important principle, because if the state doesn't let you do it, you're going to have to perhaps choose between your faith and your beliefs. Daniel had to. You all know the story of Daniel in the lion's den. Shadrach, Meshach, Abednego, same thing. And I love their quotes. He says, if it so be our God whom we serve is able to deliver us from a burning fire, he will deliver us out of thy hand, O king. But if not, doesn't matter. Let it be known, O king, that we will not serve thy God, nor worship the golden images which are set up. Kill me if you want, but I'm not going to comply with what you ask. That's the aspiration of free exercise, is that the king will forbear, the state will forbear, and let us practice our religion in a way we believe, even if it's contrary to what the state commands. Esther, also, wow, what a beautiful story that is. She put her whole life on the line, contradicting the local rules, and saved her people. They have a feast now in celebration of her. Here is the term that has to be interpreted. Congress shall make no law respecting established religion or prohibiting the free exercise thereof. The Supreme Court has never interpreted that phrase correctly in any way that's compassionate, except for very few cases, which are not the cases or the extant law today. This is just a quote from, this is the Missouri Extermination Order. People don't know this necessarily. There was an order by a governor, Boggs, in Missouri. You could kill Mormons on sight. It's a historical document and forcing the Mormons out of the community. They left Missouri to Nauvoo. They got forced out of Nauvoo by gunfire, by cannons, and by martyring the prophet because of their religious beliefs and because of their religious doctrine. They came here in Exodus of that experience. Later on, the church actually presented the very first, most famous, and in some respects, the death knell to free exercise religion, the interpretation of free exercise. The case came up by U.S. versus Reynolds, much later, 1878. Many of your ancestors spent time in prison. My ancestors did. I had one grandfather who died in prison because he was practicing polygamy. Right? In the Reynolds case itself, the Reynolds case itself raised the question. Now, unfortunately, the Reynolds case came up in a political context that almost destined the free exercise clause to being interpreted incorrectly, without any compassion, without any honor, without any humility on the part of the state. And they went to a heuristic device that's used throughout all constitutional law, including free speech and free press. And that is, whenever you want to hammer a principle like free speech, then you talk in terms of consequentialism and extreme circumstances, exigent circumstance arguments. If we allow this, the sky will fall. It's a Chicken Little type argument. If we allow this to happen, then everything will end. All life will end in the world, right? So it's a slippery slope argument. That's essentially what the court said that. What they said is, look, if free exercise religion means anything, then it means everything, which is simply not the case. Just because what the examples they gave, it would allow for human sacrifices, would allow for people to burn their spouses on a pyre. If you allow any free exercise, you allow all free exercise, therefore, no free exercise. The Reynolds case decided in a way the free exercise was reduced to a pinpoint that was not necessary. In fact, that is the law to this day, by the way. The free exercise clause itself means zero. You could erase it out of the Constitution and you would have exactly the same law that we have right now. The only thing that protects religion is not free exercise religion. It's not the free exercise clause. It's the 14th Amendment, and it's the principle of discrimination. That's because of partially the Reynolds case. We do have free exercise in indirectly, and that's how it's actually brought up. So if you have any type of protection free exercise, it ends up being brought up in other contexts. One of the most famous ways it come up, in fact, one of the most famous Supreme Court cases of all time with freedoms is Meyer versus Nebraska. There is a counterpart in Iowa as well with a Holmes dissent. In the Myers versus Nebraska, the whole question is whether or not kids can go to school, a Lutheran school, and read the Bible in German. And this was post-World War I. People were concerned about patriotism, so they didn't want the kids, until they get to high school, to learn the language, be taught in German, even in a private school. Meyer versus Nebraska powerful case, beautiful case, said, but it turns on families, not on religion. It said families have a right, parents have a right to educate their children, and because of that, we start to breathe life back in to the free, not the free exercise clause, but the experience of free religion. West Virginia Barnett, another beautiful case, where initially, Gobitis, the original case, people were required to swear a Pledge of Allegiance. In West Virginia Barnett in 1943, in the middle of World War II, they relaxed that and said, we're not going to compel people to swear an oath. Those Jehovah's Witnesses didn't want to swear to anyone but God. My goodness, aren't we humble enough to let people avoid swearing to the United States if it offends their religious beliefs? Thank goodness. In West Virginia versus Barnett, the language of free speech, however, not religion. And I don't know if Professor Fenner will talk about that. If there's any fixed star in our constitutional constellation, it has that no official, high or petty, can prescribe that what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word, act, or act in their faith. If there are any circumstance would permit an exception, they do not occur. This is my favorite case, Wisconsin versus Yoder. I know you can't see that small print probably. Let me tell you about this case. I love this case. I wish this case was law. It's not the law. Wisconsin versus Yoder, you had, and this is the same both in Iowa and in Wisconsin and some of the Midwest communities where they had the Amish. And the Amish had a system, and it was family-based system. And they would go to school to the 8th grade to learn how to read, write, do all the things you would do up until the 8th grade. And then they would pull out of school, and they would take their children, and they would teach them trades. They teach them to be carpenters, how to make chairs, how to be seamstress. And the state of Wisconsin was trying to compel them to go to school. And fortunately, the U.S. Supreme Court in Wisconsin versus Yoder, based on family rights, not religious rights, at least that's what Smith versus Oregon says, allowed the people to be exempt from those things. Now, in that case, there's a big sociological discussion of the Amish. And before they allowed this to happen, they had to show the Amish, they take care of their people, they take care of their old people, they take care of their children. They actually are not on welfare. They don't do all these things that the state said, well, we got to send our kids to school, otherwise they're going to be out in the streets doing whatever. But the Amish showed them that's not true. In fact, there were fewer Amish people that were on welfare that had problems than any other cultural basis. The Amish are a beautiful family. My goodness, what a rich heritage they have been. They won a case, but it's not primarily a Supreme Court case based on religion. And that was because of, I'm going to skip a bunch of these cases, because of this case. This is an ugly case. I hate this case. Oregon versus Smith. It actually reverted back to, and this is the law today, by the way, it reverted back to the Reynolds case. Oregon versus Smith basically argued the exigent circumstance, slippery slope argument that said a free exercise of religion gives you nothing. The only thing you get, if you get anything, and they look back at cases like Wisconsin versus Yoder, you've got to append free exercise to something else, such as family rights or substantive rights separate from religion. Religion gets you zero. Embarrassing to our constitutional interpretation. So Smith reasserted Reynolds as it's the basis. It is the law today. Shame on the court. After Smith, Congress was even so embarrassed by Smith that they enacted a rule called the Religious Freedom Restoration Act. And I was going to throw Bartles versus Iowa in there. There's the companion case of Iowa. Anyway, I'm going to skip through a bunch of these cases. We don't have time to do that. Let me just give you a summary of the point, so I won't run out of my time, so give my colleagues their time. Fast forward, what happens? Congress passes the Freedom Restoration Act, and it is still effective. In fact, that's a statute, not a principle, not a right. It's a statute. by policy basis, allows religion to have what was then given to them by constitutional principles. So the RFRA statutes, the federal statute, basically resurrects Wisconsin versus Yoder and says religion ought to be given some respect. We ought to allow religion some freedom. We ought to be humble enough to allow people to practice religion subject to a compelling state interest. If someone crosses a compelling state interest line, then we can prohibit that, but we can't prohibit it without substantial proof that's going to cause a substantial state interest. That became the RFRA statute. The Supreme Court came along after that statute in a case called City of Boerne. In that particular case, the City of Boerne case, they said, fine for the federal government, but because of federalism, the RFRA cannot establish state law. So state law, to this day, or very few states have RFRA statutes, and so state law, religion is not protected at a state level because of the Smith versus Oregon case. So that's kind of where we are now. Now, the cases you see in the press are all statutory cases, cases like Hobby Lobby, and those cases where they pass statutes that try to reassert the free exercise of religion as a matter of policy. States cannot pass state RFRA statutes now because a huge opposition from especially the same-sex community that if they pass RFRA statutes, then people will be allowed to use religion as a justification to discriminate, among other things, on same-sex basis. So here's where we are right now to this day. Here's a Roman Catholic case, Andrew. The only way religion really gets protected now, one of the famous cases recently, these two cases were kind of companion cases, is we have you can't discriminate against religion. So they have a case called the City of Hialeah versus the Church of the Babalu. And that's a very important case that these threads follow. And here's what happened in the Church of the Babalu case. The city in Florida, the city of Hialeah, didn't like the Sanarians in their community killing chickens, doing animal sacrifice. And so they said, in their community, they said, hey, look, let's just pass a general law that will allow us to persecute the Sanarians. And we'll say it's not healthy to do it, general law, and the Smith case said we can do that, we can hammer and get rid of all these chicken killers. I kid you not, you go read the case and see what they said in their community meetings. The Supreme Court came in that particular case, and said, the city of Hialeah says, you cannot target religion. As long as you have an objective, I'm not looking at religion, I'm just talking about health, and that's really your motivation, then a religion can be hammered, but you can't target them. And that is the case called the City of Hialeah. Fast forward, another famous case recently is the Masterpiece Cake case. In that particular case, a cake salesman didn't want to make a cake he believed to be artistic for same-sex couples. And the Colorado cities, in their meetings, talked derogatorily about religion, saying these bunch of religious wackos come in here and they won't sell to a same-sex couple. We need to get rid of them, much like the city of Hialeah. Because of that rhetoric in their city meetings, they triggered the city of Hialeah case and open discrimination. And the Masterpiece Cake guy was allowed to make cakes. He's still in litigation right now. The most recent case, some of you may have seen, is this Roman Catholic Diocese Brooklyn versus Andrew Cuomo. He's in his own troubles right now. Andrew Cuomo targeted the Jews. He targeted the Catholics in many ways because he put out an executive order based on the COVID that they can't come together and worship, even though you can do all these other things. You can publicly protest. You can get all these people together, but you can't go into the synagogue. You can't go into the Catholic churches. In that case, the Supreme Court just recently said targeting. You can't target. All right, so let me conclude and make a point here, and that is right now, if we get any type of freedom of religion at all, It comes through discrimination laws and by targeting. It doesn't come from the free exercise clause, the free exercise clause in the United States. You could put a pencil through that clause and everything would be exactly the same. You protect religion only from free speech or from family life, not from religion, unless you do it by statute. I'm embarrassed by that holding, by the way. I love Wisconsin versus Yoder. Here's my point, two-part point. I'm part of the individual. Me personally, I'm choosing this day to follow God. If it means I go to jail, I'll go to jail, right? I love Joshua. I love Daniel. I love my ancestors who put everything on the line because of their religious beliefs, even if it meant to go to prison. One of my grandfathers died in prison over polygamy. I'm proud of him, right? I'm not proud of a country that doesn't understand the free exercise of religion and forces us to get to religion through other arguments, including free speech and including discrimination laws, 14th Amendment. That is the current law today. It doesn't sound right to your ears, perhaps. Trust me, I've read the cases. The free exercise clause protects nothing other than discrimination. It ought to protect much. I love religious liberty. I fight for religious liberty. I pay homage to people like the Amish who sacrifice everything for religious liberty. And that's my talk.